Watch this before you do anything else. Going to court should be your last resort. Sometimes you have no choice and have to go to court to get a court order. But most of the time, you should only go to court when nothing else works. We are not talking about criminal cases or cases where there is violence. I'll talk about those in a few minutes. Going to court takes a lot of time, no matter if you are the one suing or being sued. It costs a lot of money. It is difficult to fill out all the paperwork correctly. It's also difficult to know what to do and when to do it. The court will not do your work for you. A lot of the time, no one is happy with the result. Therefore, before you begin, think about doing these things. 1. Collect all your facts, not opinions, beliefs, or desires, but facts that you can prove. Get all the documents you need to prove your facts. Find all the witnesses that can prove your facts are true. 2. Educate yourself about your case. Go to the library or bookstore and read about your rights and your duties. Read also about the other person's rights and duties. For example, if this is a landlord-tenant problem, read about the landlord and tenant's rights and responsibilities. You can also find information on the internet, your local bar association's lawyer referral service, or nonprofit agencies who specialize in the area of law in your case. 3. Find someone who is not involved to play devil's advocate, to try to find holes in your facts. Someone outside the case can also give you other ways to think about your case. Review and fix your position depending on what you learn from this. 4. Contact the other person by phone, email, or in person to try to talk about your problem without yelling or name-calling. Ask them to tell you what you think about the problem and what facts they have that you don't know. Then tell them your version of the problem. Talk about it and see if you can come to an agreement that both of you can live with. If you are afraid of the other person or you know that you can't talk to each other without yelling or name-calling, skip this step. You must skip this step if there is a restraining order or some other order that prohibits you from contacting the other person. 5. Try to find a neutral person to help you and the other person talk about your disagreement. This is called mediation. The mediator can be a neighbor, a boss, a minister, rabbi, a priest, imam, a professional mediator, or a friend you have in common. Ask the other person if he or she would be willing to go to mediation to try to reach an agreement and solve your problem. 6. If you're able to reach an agreement, put it in writing. Write down what your agreement or compromise is, and both of you sign it. That becomes a contract between you and the other person that all of you must follow. 7. If your situation is a divorce, a guardianship, or establishing who the parent of a child is, you will still have to go to court, but it will be a lot easier because you have an agreement to give to the court to help you finish your case. Your agreement will become part of the court order, and the judge will sign it and give you each a copy. These tips don't work in criminal cases or domestic violence cases. If you have a criminal case, you must work through the police department and the district attorney. If you have a domestic violence case, get your police report and go to the domestic violence clinic for help. If there are tapes available on domestic violence, watch or listen to them. If you can solve your case without going to court, you will probably be happier with the result and you can solve it more quickly. But if you can't solve your problem without going to court, educate yourself about the process. Watch or listen to before tapes to help you start your case smoothly. Watch or listen to these tapes as many times as you need to help you better understand how the system works and what you should do.